Imagine this. You are pulled over by the police for speeding, whatever, some sort of minor traffic stop. The officer is very polite, but then he says, "Mind if I take a look at your phone?" What do? Most people panic and they say yes, just to be cooperative. Maybe you are smarter and you say, "Don't you need a warrant for that?" And the officer says, "Not if you use your fingerprint to unlock it." Or worse, they take your hand and they force your thumb onto the sensor. Did that officer just break the law? The answer may terrify you. The Supreme Court has said police need a warrant to search your phone, but cops have found 3 dangerous loopholes to get in anyway. And the third one, the biometric one, was just blown wide open by a case called United States v. Payne. By the end of this video, you will know the one exact phrase that slams all 3 of these loopholes shut. And I'm going to show you proof of what happens when you don't use it. First, let's set the baseline. What is the actual law? For this, we look to the Supreme Court of the United States. In 2014, in Riley v. California, the court unanimously ruled that your cell phone is not like the wallet in your pocket. They said, and I quote, "A cell phone is your digital record of nearly every aspect of your life." And this goes back to the founding of this great nation. The Fourth Amendment was written to ban writs of assistance. That's general warrants that let British soldiers search any part of your home for anything. The Supreme Court basically said, your phone is the modern day equivalent of your home. I want you to think about what's on your phone right now. Your private texts, your medical information, your bank account information, your location history, everywhere you've been with that cell phone in your pocket. The Supreme Court recognized this. They ruled that to search your phone, police need what they need to search your house, a warrant signed by a judge. So you're protected, right? Well, that warrant is the front door, but police have found 3 other ways in. Number 1, let's start with the most common and most dangerous loophole of all. The officer asks, "Mind if I take a look?" The second you say yes, you have voluntarily waived all of your Fourth Amendment rights. The warrant requirement is gone. You might be thinking, so what? Nothing to hide. That could be the worst mistake you've ever made. Look at this. This isn't a theory. This is a federal indictment. According to prosecutors, these officers would pull people over, get consent to search their phones, and then hunt for private or see photos of the driver or their spouse. Then they'd use those photos to extort the drivers for cash. They weren't looking for evidence of a crime. They're looking for blackmail material. And it all started because people consented to officers accessing their cell phones. I want to be real firm about this to the whole "I have nothing to hide" crew. You are never just proving your innocence. You are giving them an unlocked door to your entire life. Okay, that's loophole 1. Loophole 2 is what happens if you're on parole or probation. And you might be thinking to yourself, "I'm going to stop watching this video. I'm not on parole or probation. I'm never going to be." But understand, this slippery slope leads us to the third exception, and you definitely want to stick around for that third exception. When you're on parole or probation, you have what's called a diminished expectation of privacy. You've already agreed as a condition of your release to be searched at any time or without cause. And that leads us up to this case, U.S. v. Payne, which is the subject of exception 2 and 3. Mr. Payne was on parole, and he gets pulled over for tinted windows. He's nervous. Officers find cash, a key, and his phone. Payne refuses to give them the passcode. I give Payne credit for that. So what did the officer do? He forcibly grabbed Payne's thumb and used it to unlock the phone. Inside, they found videos of drugs and money, which led them to a house with more drugs. Payne was sentenced to 12 years in prison. Payne argued the search was illegal. He said, "My parole conditions said I had to provide the code. It didn't say they could force my thumb." The Ninth Circuit Court of Appeals disagreed. They said his general parole condition that any property under his control could be searched was enough. The officer was justified. So for anyone on parole, that's a massive warning. But the scariest part of the Payne case is what it means for all of us, even those not on parole or probation. Loophole 3. Payne made another argument. He said forcing his thumb onto the phone violated his Fifth Amendment right, the right against self-incrimination. He argued that forcing him to unlock the phone was forcing him to testify against himself. And this is where the law gets really creepy. The court again disagreed, and they explained why using an analogy. Key versus combination. Think of a wall safe. A passcode, the court says, is like the combination to the safe. It only exists in your mind. Forcing you to tell the numbers is testimonial. It requires cognitive exertion, and you're telling them the contents of your mind. The Fifth Amendment protects that, as it should, right? But your fingerprint or your face, the court said, that's not a combination. It's a key. It's a physical object, just like a blood sample or a key to your house. They're not asking you to think. They're just taking something. The court literally said the officer could have unlocked the phone even if Payne had been unconscious. Let that sink in. The law, as it stands, is that police cannot force you to tell them your passcode. But it's open for interpretation whether or not they can physically force your finger or face onto the phone to unlock it. That is some scary stuff. I'm sorry. Now, if you're watching this far, you're probably thinking what I'm thinking. This is insane. Why didn't the officers just get a warrant? Let's apply some common sense. Was Mr. Payne leaving the scene? No, he was in handcuffs. Was the phone leaving the scene? No, the police had it in their possession. Was his thumbprint going to magically change? No, it was not. The police had all the time in the world to call a judge, present their evidence, and get a proper legal warrant. But they didn't do that. They chose brute force on the side of the road to save themselves some paperwork. And the court said, good work. And this leads to a second, scarier question. What if the person resists? What's the next step? Do the police tase them? Do they break their finger to get the phone open? It's absolutely insane. The entire point of a warrant is to have a judge decide what's fair to avoid this roadside violence. If a judge orders you to provide your thumbprint and you refuse, the remedy is contempt of court. This is a civilized legal process, not a wrestling match on the side of the road. Now, this is a massive developing gray area in the law, and it's a legal fight you do not want to be the star of. In fact, Payne judge wrote in a bizarre note, a sort of legal backdoor. He said the outcome might have been different if the officers had forced Payne to choose which finger to use, because apparently choosing a finger involves your mind, but having your thumb forced onto the sensor does not. If that sounds like ridiculous, hair-splitting nonsense, you're right. But it's the law that sent a man to prison for 12 years. This is the minefield you are walking through. So, how do you protect yourself from all three of these loopholes? You cannot control the Payne ruling. You cannot control the key versus combination debate, but you can control the first loophole, consent. Remember, in the Payne case, the officers were only able to force his thumb after they had lawfully seized the phone, which they could do because he was on parole. For you, a regular citizen at a traffic stop, they don't have that right. They still need a warrant unless you consent. This brings us to the single most important thing you will hear today. If an officer asks to see your phone, you have one response. You must be polite, you must be calm, and you must be firm. You say these 5 words. I don't consent to searches. That's it. Don't add anything. Don't say, I know my rights. Don't say, you need a warrant. Don't argue. Any extra words can be twisted and used against you. Now, sometimes officers will push. You must have something to hide. Something must be on there you don't want me to find. You respond again. I don't consent to searches. If they say, we can just get a warrant, you're just making this hard. You say, I do not consent to searches. Be a broken record. You are not giving them consent. You are not giving them the key. You are not giving them the combination. You are forcing them to go to a judge. And what about your phone's settings? As a criminal defense attorney, my advice is simple. Turn off biometrics. No face, no thumb, no finger. Have a pretty long alphanumeric code. Don't make it something silly. Make it something crazy that only you're going to figure out. By using a strong alphanumeric passcode, the police cannot force that out of your head. They cannot force that out of your thumb. Your phone is your house. The Riley case built a strong front door, but consent is leaving that door unlocked. And biometrics, that's leaving the key right under the mat. Don't do it. Protect your data, protect your family's privacy, and always remember those 5 words. I don't consent to searches. The law surrounding cell phones and biometrics is changing every single day, and this fight will end up at the United States Supreme Court. If you want to stay updated and know how to protect yourself, subscribe to this channel, hit that notification bell, like this video, If you watched this far, you must like me a little bit. Come on, give me a comment, a little bit of love on it. Don't be shy. I really would appreciate it. If you want to leave a mean comment, that's fine too, but try to be civil. I like to read these comments when I'm drinking my coffee in the morning. And only one time I spit my coffee out all over my computer screen. My wife thought I was having some sort of episode. Don't do that to me. Be civil in the comments. I love comments. I literally read all of them. I try to respond as many as I can. I'm a busy guy. Don't get mad at me. If you're facing charges in Indiana, give me a call, 317-632-3642. I'd love to talk to you about your options. But most importantly, I want you to remember to always plead the fifth.